Hey everybody, hope you're all staying healthy and safe. Today we're going to go over Citizenship and Civil Rights Section 3 on equality before the law. Assuming it will let me. There we go. So, our objective today is to identify the effects of segregation and integration and to examine what it means to be, quote, equal before the law. So, as we're going through these notes, there are three questions I want you to think about. First of all, what is segregation? Second, what is integration? And third, what does it mean for everyone to be equal before the law? So, the first thing we want to talk about is the Equal Protection Clause. We've talked about this before. It's the section of the 14th Amendment that states the laws of the nation in each state must treat any given individual in the same way as it would treat other individuals who are in similar conditions and circumstances. What this means is that states cannot draw unreasonable distinctions between any classes of persons. So they can't make a major distinction between, say, the rich and the poor, or between black and white. That second one is going to be where we are going to be looking at things today, mostly. So discrimination is to treat certain categories of people differently than people that fall into other categories. Usually we see this in situations such as racism or bigotry or Islamophobia, xenophobia, fear of people who are different. This isn't to say that all discrimination is necessarily negative, though it usually carries that connotation. But the government has been able to discriminate between different classes of people. For example, someone who robs a bank versus someone who doesn't rob a bank. The government, though, cannot discriminate unreasonably. So you can't treat one class of person unreasonably different than another class of person. Part of all this is based on what's called a rational basis test. The Supreme Court asks if a classification bears a reasonable relationship to the achievement of some proper government purpose. So remember, the government's purpose is to provide protection for its people, for the people's life, liberty, and their pursuit of happiness. If the government is pursuing those reasonable purposes, then they can create classifications on a reasonable group. So, for example, they can create a classification that says if you rob a bank, you will go to jail. If you murder somebody, you will go to jail. The Supreme Court case Michael M. versus Superior Court from 1981, a California law says a man who has sexual relations with a girl under the age of 18 to whom he is not married can be prosecuted for statutory rape, but the girl cannot. This court case basically bore a reasonable relationship to a government goal of trying to reduce teenage pregnancy, so the Supreme Court upheld that law. The court sometimes applies what we call a higher standard in some equal protection cases. One situation, cases dealing with fundamental rights, such as the right to vote, travel between states, or anything related to First Amendment rights. Second situation, cases dealing with suspect classifications, such as those based on race, sex, or national origin. So this comes down to what we call the strict scrutiny test. State or federal government must show that a law is not related to an ordinary governmental purpose, but to a compelling governmental interest. What does compelling governmental interest mean? Well, in the court case Orr versus Orr from 1971, an Alabama law that made women but not men eligible for alimony, for payments after divorce, was held unconstitutional because the law's distinction between men and women did not serve any compelling government interest. So, traditionally speaking, when a man and a woman divorce, women have received alimony payments because, at least up until the past about 20 or 30 years, women were usually staying in the home, being mothers, taking care of the home, while the men were out actually being the ones earning money. And so if a woman was suddenly cut loose from that man, she didn't have any money. She didn't have any way to make money. She'd been a homemaker all of her life. She didn't have, a career to fall back on. But that's changing more and more. More and more households have both the husband and the wife, if both are present, um, actually working now. And so the Supreme Court said you can't say that alimony payments can only go to women. Just doesn't make sense. Segregation. We looked at this a lot when we were watching the Ernest Green story. Segregation is the separation of one group from another on the basis of race. Throughout United States history, following the Civil War, leading up to just after World War II, we have what are called Jim Crow laws. Laws aimed at African Americans that frequently required segregation by race in the use of public and private facilities. So this included water fountains, bathrooms, restaurants, hotels, stores. A lot of it was based on the Supreme Court case Plessy versus Ferguson from 1896, where the court ruled that separate but equal was okay under the Equal Protection Clause, as long as the different facilities for African Americans and whites were equal, it was okay that they were separate, according to Plessy versus Ferguson. Now, we know that can't be the case, that separate is never equal. But back then they were like, no, it's separate. If it's equal on both sides, then it's okay. Missouri ex rel Gaines versus Canada from 1938 featured Lloyd Gaines, an African American who applied to law school at the University of Missouri, which did not allow African Americans to attend. The court ruled that the school could allow him to attend, or they could create a separate law school for him. Missouri went ahead and just allowed him to attend. Other Supreme Court cases, such as Sweet versus Painter and McLaurin versus Oklahoma, found that separate facilities for African Americans were always far from equal. This is all leading up to the Brown versus Board of Education case in 1954, where Brown was a small African American child who had to be bused clear across town to the nearest African American school rather than attending the white public school that was literally a block away from her house. The court ended up striking down the idea of separate but equal public schools, which led to the court instructing the states to start dismantling segregation with all deliberate speed. This led to the process known as integration, the process of desegregation. States frequently attempted to block integration in the 50s and 60s. We saw this in the Ernest Green story movie, but it happened all across the South especially. Some states, including Arkansas, went ahead and just shut down their public schools at some point to prevent African Americans from integrating into white schools. It was a big mess. The Civil Rights Act of 1964 forbid the use of federal funds to aid any state or local activity in which racial segregation was practiced. So we see kind of the progress from Plessy versus Ferguson, where they say separate but equal is fine, to the 1960s, where they're saying, no, you can't segregate. You can't separate people based on their race. The court case Alexander versus Holmes County Board of Education in 1969, the court ruled that the time for desegregating at all deliberate speed had passed, and schools should be immediately integrated. So here we are, 15 years after Brown versus the Board of Education, when the Supreme Court said schools should integrate. Now they're saying schools have to integrate and they have to do it right now. We are tired of you guys dragging your feet on it. So we have a couple of different kinds of segregation we have to look at. We have de jure segregation, which is segregation authorized by law. This was essentially abolished in 1970, or by 1970. Many states tried to avoid integrating schools through the use of private schools. Sometimes that worked, sometimes it didn't. We still have what's called de facto segregation that exists in fact even if the law does not require it. So we can see this through the impact of housing patterns created by de facto segregation in schools even today. So across most of Fairfax County, for instance, you can see changes in population patterns. You can see groups where certain types of individuals live and are going to attend certain schools, and then other schools where the populations are going to be mainly, white. Because Fairfax County is a fairly wealthy county, and so a lot of the people that live there traditionally have been white. Bradwell versus Illinois. Let's look at gender, and sexual orientation inequality. So Bradwell versus Illinois from 1873 was the first case challenging sexual discrimination. The court ruled that it was okay to bar women from practicing law because they weren't smart enough? I don't know. It's a weird case. Reed versus Reed in 1971 struck down an Idaho law that gave fathers preferences over mothers in administration of their children's estates. So when one parent dies, they've got their will, they have what's called an estate. It's all their worldly belongings, and it usually gets divvied up among their children. So if you're a child and you've got no other living relatives than your parents get to decide what happens with your estate. Reed versus Reed said that you couldn't leave it up to just the dads, that the mothers had to have an opportunity to be the one to administer your estate. Taylor versus Louisiana from 1975 held the 14th Amendment's Equal Protection Clause forbade the students excluding women from serving on juries. So up until 1975, they could say, well, we don't really want women serving on juries. No, we don't want them. They're not going to be able to make a good decision in the jury or whatever nonsense. So the thing to keep in mind, classification by gender is not in itself unconstitutional. The law can discriminate between men and women. But laws that treat men and women differently can be overturned if, one, they intend to serve an important governmental objective, and two, they are substantially related to achieving that goal. With that in mind, let's look at a couple of other related cases. The U.S. versus Windsor, 2013. The court ruled that the Defense Against Marriage Act's denial of federal benefits to gay and lesbian couples violates basic due process and equal protection principles. So the Defense Against Marriage Act was a law passed about 10, 15 years ago, I believe, that defined marriage as between a man and a woman, and said that only a married couple that is a man and a woman could receive federal benefits. So health insurance, pensions, things like that. U.S. versus Windsor strikes that down. And then Obergefell versus Hodges in 2015, 2 years later, the court struck down state bans on gay marriage, said that it violated equal protection principles. Gay marriage was thus legalized across the entire country, regardless of what states wanted. So you have 10 questions here. Answer those 10 questions. Submit your answers in Google Classroom under this assignment, please. Look for the next set of notes to show up here in the next day or two. Be safe, everybody.